Good evening, good afternoon as well. My name is Aurélien Lorange with my colleague Anna-Maria Urbanova from the Corax Foundation will be hosting this match. This is the first match for this new edition of the Inter-University Law Debate Tournament. Today we have the first match of two teams representing two institutions, one in Brazil and one in the Netherlands. They will be starting the competition today, this week. This is the first of several matches during the group phase. And of course, they received the topic 7 days before in order to research and to find arguments to prepare that debate. So I have to mention that it's not the first time that Tilburg University and Domelder has a match, because last year they had already a match. It was the first participation for the Dutch team, and it was actually another participation for the Brazilian team. So this year, by chance, they start the competition together. So I would like to give the floor now to the students. The students will introduce themselves for the audience, for the judge. So I would like to start with Miss Maria Eduarda Milagres Fonseca, representing Domelder Law School. Yes, go ahead.
My name is Maria Eduarda Milagres. I'm from Brazil, and I'm here representing Domelder Law School.
And which year of studies? Which year of studies? In which year of studies are you?
I'm sorry.
Yes, in which year of studies? Are you in second, third, fourth? Fourth year. Yes? Yeah, okay. Thank you. So now I will give the floor to one member of the team, so Mr. Spiridon Kontos for Tilburg University. Could you introduce yourself as well?
Hi, good afternoon. I'm Spiridon. I am in my second year of my studies, and yeah, very excited.
Thank you very much. Now, second member for the team from Brazil, Miss Sofia Campolina. Could you introduce yourself as well?
Am I audible?
Yes.
Hello, my name is Sofia Campolina. I'm from the THIULDT Law School, and I'm in the third year of law.
Thank you. Welcome. I will give as well the floor to one coach within the room, so Professor Dr. Lorena Bastianetto. Could you introduce yourself as well?
Hello, Professor Lorange. Hello, delegation from the Elder and also from the Netherlands. It's a pleasure to be here. Thank you very much. My name is Lorena Bastianetto. I am the coach for the 6th year for the Hague debate. I'm sorry for having my camera turned off, but I'm in traffic, so I hope we have a great competition today. Thank you, Professor.
Thank you very much for joining. So I have to precise that on the side of Tilburg University as well, the team has been coached by Mr. Rami Fransawi, who participated last year representing Tilburg University. So this year he is coach for the team from Tilburg University. We have as well present in the room Professor Martin Zvec, who is one of the three judges for this match. Professor is from Masaryk University in Czech Republic. Could you maybe introduce yourself as well?
Yes, sure. Good afternoon. Once again, my name is Martin Schwetz, and I'm an assistant professor at the Masaryk University. I'm specialized in international European energy and investment and law, and I'm very excited about all your arguments. And I would like to wish you good luck.
Thank you very much for joining. So you received the topic 7 days ago, more than 7 days ago actually, that was actually connected to that particular theme starting the competition. So the unique topic for this match is the categorization or identification of the largest polluters should be done based on companies or industries rather than countries of origin. So now I will share my screen in order to do the allocation of position live in front of the teams as well on YouTube. So you will know in a few seconds which position you will have to defend for the match, and after that you will have 5 minutes to review your notes. We will count down, and after we start the match. So normally you should see in a few seconds my screen with the wheel, with the randomizer, where you see there are two possibilities for each team, so to be in favor or to be against the motion. Two possibilities for Domander Law School, two possibilities for Tilburg University. So we click in the center and we'll know the result for this match, which position it means. So the result is that Domander Law School will defend the position in favor of this motion, and Tilburg University will defend the position against this motion. It means that concretely, Domander Law School will start the match because they have the position in favor, and they will defend the position that the categorization or identification of the largest polluters should be done based on companies or industries rather than countries of origin, while Tilburg University will defend the position that the categorization or identification of the largest polluters should not be done based on companies or industries rather than countries of origin. My colleague will share her screen with the countdown of the 5 minutes. So during these 5 minutes you can close your camera and audio to review your notes, and after that we will start the match. Voilà. Voilà, nous allons donc commencer. Vous pouvez ouvrir vos caméras. Donc nous allons commencer le match. Donc, sorry, I was speaking French because I was writing French. So now we'll start the match, so you can open your camera. So Domeder Law School got the position in favor. So this is Domeder Law School will be starting with the introduction. So I would like to give the floor to the team from Domeder. You have 4 minutes for your introduction.
Am I audible and visible?
You are audible, and now you are visible. Yeah.
Can I start?
You can start.
Honorable judges, counterparts, and others present, greetings. My name is Sofia Campolina, and alongside my fellow colleague Maria Eduarda Milagres, we defend the thesis that the categorization and identification of the largest polluters should be done based on companies and industries, rather than countries of origin. After all, Excellencies, although the international responsibility for environmental damage lies on the states, it is undeniable the most appropriate policy is to hold companies accountable for the harm they cause, since they tend to follow an economic logic and detriment to a more sustainable one. It is evident that with globalization, there is companies, as is the case of Saudi Aram, with market value greater than the GDP of some countries, such as Tunisia and Syria. Companies as this are major financiers of states, reason why environmental protection policies should be done based on those corporations, considering their great economic power and influence. Thereby, the disclosure of data by company generates greater transparency regarding their operation. Moreover, due to the internationalization of business effects, companies now are operating simultaneously in many jurisdictions of the international society. For this instance, the energy company Chevron, the second largest polluter in the world, has its headquarters in the United States but branches out to countries such as Nigeria and Indonesia. Hence, the lineup by companies in the view of a global policy enables better governmental control mechanisms. In municipal law, when applying the German theory of Drittwirkung, also known as the third-party effect, people a legitimate claim against private entities. Hence, the institution of public policies aimed at combating environmental crimes is a legal obligation of governments, but environmental rights are not only opposed against states, but also against private legal entities. Ergo, why we defend that the categorization of the largest polluters should be done based on companies. As an example, it's essential to mention some of the biggest corporate environmental disasters, as Brumadinho's dam collapse in Brazil, in which a burst of a dam led to the death of several people and animal species, and the loss of a large sum of the local vegetation. Another unforgettable tragedy is the oil spill from the Deepwater Horizon marine platform. That reminds us how vicious companies can be to the environment. Besides, we must remember the Barcelona extraction case from ICJ, which established a criterion for the identification of a company's domicile. According to this criterion, countries hosting the largest polluters could be easily identified. Therefore, we base our arguments on 3 main points. First, private companies are liable for their wrongful acts, and not just the states in municipal law. Second, an individual perpetrator, according to the third-party effect, can sue another private entity and not just the state for the violation of environmental human rights. And third, the categorization of polluters by companies is more efficient as a global policy as it moves towards transparency in a globalized world. Thank you.
Thank you very much. So now we'll give the floor as well for the introduction. 4 minutes for Tilburg University. You may start.
Am I audible?
Yes, yes.
Okay, so I will start in just a second. Honorable judges and dear opponents, we are arguing against the motion, and we believe that this debate is important in several processes and for several reasons. So we believe that three things are important. We want to be able to assign moral and legal responsibility for this pollution. Secondly, we want to be able to craft legislation to reduce pollution. And thirdly, we want to enable an individual's choice in their capacity as a voter and as a consumer. So let's firstly contextualize this debate. Top polluters are generally seen as the most responsible for pollutions and the ones that stakeholders are most willing to hold accountable. And if top polluters are firms rather than states, international lawmakers and civilians alike will seek to hold them accountable rather than states. In the case of lawmakers, this means that creating different laws and frameworks that target firms directly rather than assigning duties to states is necessary. So what does the status quo look like in this case? So in the status quo, categorization by country means that countries are held accountable for pollution produced within their borders, and those countries, the national governments, are responsible for reducing pollution through regulation. Why do we think that the status quo should remain as such? We are going to bring you two main arguments. The first one, three main arguments. The first one first two I'm going to say, and then my partner is going to develop on the last one. So the first argument is that governments are most effective at reducing pollution, and this is incredibly important because ultimately we really value effectiveness as we want this pollution to be reduced as quickly and as thoroughly as possible. So company or industry level responsibility is very difficult to assign because of the intricacies of long supply chains that currently in the globalized world inevitably are going to occur, these long supply chains. And this diffuses responsibility across firms that produce certain goods. States and state level categorization is better at decreasing pollution for several reasons. Firstly, a state has access to the bigger picture, so it's able to properly identify where most of the harm is being done. Focusing on the company or industry level often results in ignoring parts of complicated supply chains, which, as I said, are inevitably part of the globalized work. For example, focusing on agriculture pollution would place exclusive focus on agricultural producers, which would be forced to reduce the emissions with little ability to do so, and sideline the responsibility of other people involved in the process. So, for example, manufacturers of chemical fertilizers that are very largely responsible for the pollution caused by agriculture. So, one single industry is not able to regulate itself because of the intricacies of supply chains. And ultimately, the government is the only actor that is able to see the bigger picture. So focusing on the country level allows supply chain ecosystems to be regulated properly. Secondly, states have the ability to use their exclusive legal authority to introduce effective regulatory and economic incentives that fit well to the country's circumstances. We will develop on that in further speeches.
Thank you very much. Now we move to the first rebuttals. So the first rebuttal by Domelder Law School. You have 2 minutes.
And audible.
Yes, you may start.
Honorable judges, we thank our counterparts for their presentation, although we do have to disagree with a few points of their theses. Although states are the trustee of natural resources and do have a fundamental role, it should be reminded that environmental public policies nowadays are not under the reserved domain of states anymore, being considered a juridical obligation due to its global transboundary effects. International law won't let enterprise substitute states for wrongful acts. For this instance, the landmark decision by the Dutch Supreme Court, THIULDT Foundation versus the Netherlands, confirms that your state has binding legal obligations towards the environment. And due to the third-part effect, drittwerken, it directly affects the activities of private companies to environmental obligations. Moreover, the deconstruction of the Kivit-Amter theory is an example of how private sector has rights but also legal obligations as a duty to notify potentially affected countries on activities that may have impacts on the environment. In other words, as international environmental rights are in the process of being considered a jus cogens norm, it reveals public policies as legal obligations, as now companies have to inform all the inherent risks regarding their activities. And that's exactly why the categorization of the largest polluters by companies would bring several benefits to all the international society. Thank you.
Thank you very much. So now we give as well the floor for the first rebuttal to Tilburg University. You have 2 minutes.
Can you hear me?
Yes.
Okay. Your Excellencies, states are legally responsible for pollution within their borders and should be held accountable for that. Many reasons for this. First, international legal agreements have established the responsibility of countries over pollution that happens within this jurisdiction. This could be the Paris Agreement, the United Nations Framework Convention on Climate Change, or the Rio Declaration 1992, specifically referring to Principle 2. Another way to justify the same claim is that there is precedent in national law for states having a duty of care towards the citizens in protecting them from environmental harm, as seen in the State of the Netherlands versus THIULDT Foundation, which was brought up by the other side of the house as well, right? If the states have a duty of care, then it follows that they are accountable for pollution within this jurisdiction. Third, states have responsibility and authority over their territories as established by the principle of sovereignty. The principle of sovereignty, which claims that states are the primary actors in international relations and have exclusive control over the territory and citizens, as established in the United Nations Charter, the International Covenant on Civil and Political Rights, the Vienna Convention on the Law of Treaties, and the like. Categorizing polluters based on companies and industries undermines this principle by shifting the responsibility away from national governments and onto corporations. Pollution made within the borders of a country is a pollution that that country is responsible for. Why is this legal responsibility important? The fact that the law currently finds countries responsible for pollution means that this is an inherently more credible viewpoint. International law is the result of a legal hierarchy which starts from the people and ends up in legislation. Hence, the status quo is a choice that has already been made by the world, and the will of the people must be respected. And on the second level, the lack of legal justification on binding frameworks for company responsibility means that a new framework would have to be created, which is a slow process, at the end of which we would be better off using our current system and maximizing effectiveness out of it. For all the above reasons, thank you.
Thank you very much. So now we move to the second rebuttals. So it means the second round of rebuttals. I would like to give the floor to the team of Dom Helder Law School in Brazil. You have 2 minutes.
Audible?
Yes, you may start.
Considering the companies act nowadays in multiple countries, including on the metaverse, our point of disagreement here is not about the absolute necessity of responsiveness of the polluter, as stated by the principle the polluter pays. What we do stand for is that we need global public policies with the direct involvement of global actors. Global public policies can include issues related to regulation, redistribution, and global social rights, as has been done in Agenda 21, an action plan to be adopted globally, nationally, and locally by Organization of the United Nations, the governments, and the civil society in all areas where human actions can impact the environment. We need to make a healthy displacement of the traditional state centric view of global public policies. After all, the more global actors shy away from international cooperation in order to protect their sovereignty, the more often they fail in dealing with global challenges, losing in these failures little by little exactly what they should seek to protect. So, even in times where sovereignty places great barriers for solidarity and cooperation, the categorization of the largest polluters by companies and industries would break this logic, aiming directly at the source of pollution as a global policy. Thank you.
Thank you very much. So now I give the floor as well for the second round of rebuttals to Tilburg University. You have 2 minutes.
Can you hear me?
Yes?
Okay. Dear panel, states have the exclusive ability to use their legal authority to introduce effective regulatory and economic incentives that fit the country well. This is something unique to states and that corporations cannot do. Whereas an international regulator that would probably try to regulate these companies can only create uniform requirements for firms across a sector. A state can help struggling firms or small businesses make transitions away from polluting methods through subsidies and top tax breaks or other economic incentives. There is also a reduction in conflict between laws that will be drawn between different legal authorities by clarifying the one single legal authority that is ultimately responsible. So this is the state. And for example, the Nefson v. Araya case in the Canadian Supreme Court, that has been a precedent case, was held there that Canadian firms can be held accountable by Canadian courts for the actions of their subsidiaries. Please notice that this clashes directly with their argument about companies operating across states and therefore it being difficult to hold them accountable. Actually, we don't think so, and we have seen case law prove otherwise. This is an example that that national laws can hold multinational companies responsible for their actions. Because states are the primary actor in international law, they can ultimately be held accountable and pressured in a certain way. Governments are a legal entity that exists despite changing circumstances and events because they have stronger disincentives to escape accountability, because that accountability functions in a different way for corporations. This will be developed in our next speech.
Thank you very much. So now we'll move to the conclusions. This is the time for the conclusions. So we'll start with the conclusion by the team from Domelder Law School. You will have then 2 minutes.
Am I visible and audible?
Yes, you may start.
Finally, honorable judges, to reassure that the federalization should be done based on companies, may we look back to what was established. As of today, a variety of framework conventions and soft law address the importance of environmental responsibility of states. But we cannot forget that above all arguments lies one, that due to the internationalization of business affairs, it's evident the phenomenon of tourism of rights as multinationals search for regulatory flexibility to explore, as it is the case of the oil exploitation at Virunga Park. That puts at risk one of Africa's richest natural treasures. And even though its pristine wildness has been granted protection under Congolese and international law, companies from Europe and elsewhere are pursuing plans for oil extraction in and around the park. By consequence, the identification of the largest polluters and environmental perpetrators by company would again bring better transparency to the acts of the private sector in order to prevent environmental tragedies, as remembered from the Madin, from happening. Lastly, it is our concern to respect environmental law as it is today, but it comes a time to recall that in order to achieve proper responsibility, the private sector must, by application of Drittwirkung, be held liable for their wrongful acts in municipal law, as it is clear how important environmental protection is and that responsibility at every level is mandatory. Thank you.
Thank you very much. So now we'll give the floor to the team from Tilburg University also for the conclusion. I would like to give 2 minutes now for the team from Tilburg. You may start.
Your Excellencies, two clashes in this debate. One, who is and should be accountable, and two, where is pollution reduced more effectively? First, who is and should be held accountable for pollution? While firms might be closer to the activity that is being done, ultimately they have little authority and choice on what they're supposed to do. States, using their sovereignty, which is an exclusive right that states have in international law, are ultimately the final decision makers on what happens and what doesn't. This authority is what makes them different from any private actor, which at the end of the day will have to obey the will of the state. Firms can be held accountable on our side of the house as well, by states, in accordance to an official legal hierarchy that starts from international law, continues through states, and ends up through states regulating firms directly. We believe that because of this exclusive duty that states have to other states and to their citizens, they should be held accountable. Second, where is pollution reduced more effectively? Two subclasses here. One, which stakeholder has more power to cause change, the state or the firm? We clearly explained to you why the state has a bigger ability because of its higher scale and options regulation-wise to create circumstances for lesser pollution. And on comparison, a state has little of the incentives necessary to protect the environment, rather caring more about profit, versus a state which has a duty to protect its citizens. Where will firms be regulated more effectively? From a state that has the ability to hold them accountable. Thank you.
Thank you very much. So now we are done with the two conclusions, so it means that this is the end of this match. From now, you are not anymore under evaluation. So from now, of course, we can ask for your impression, for as well some information how you prepared the topic, how it is connected to your studies eventually, and as well a few first impressions from Professor Svech. Sorry for pronunciation. I think each time I make the mistake on your name because you say it and each time I forget. But yeah. So I would like to give the floor first to the student from Domaine de Law School, Miss Maria Eduarda Milagres Fonseca. Could you tell us about your impression, how you prepared your research as well, maybe on the topic? No, we don't hear you yet. Not yet. Not yet.
If I may,
yes,
I can...
Yes, now, yes. Oh, sorry, you are...
My fellow colleague is having problems with the connection. So if I can get...
Yes, please.
Thank you. She's there.
No, we hear you. Please speak. Yes, you can. Not anymore, actually. We heard you a few seconds.
Hello, can you hear me now?
Yes, please go, please.
I'm sorry for these technical problems. And firstly, I would like to thank all the organization for this competition, as it's very interesting and very good to study all this. I would like to thank our counterparts. It was very good to debate with all of you guys. I really liked it, and it was very productive. I'm very excited for the next phase.
Thank you very much. Now I give the floor to one student from Tilburg, Mr. Spiridon Contos. Your impression, how did you prepare as well the research maybe?
Interesting question you ask.
Mm-hmm.
The most accurate answer I can give is just a decent amount of time on the computer reading at the cases, and a decent amount of time trying to figure out what the argument sounds nice.
Mm-hmm.
Not sure if there no point into getting into the specifics, but we were generally very excited, and we found the topic interesting. So very happy to be here, and it was great debating with the students from THIULDT, if I'm pronouncing it correctly. We found that a lot of the stuff that was brought up was very interesting and fun as well. I think it's the right word.
Thank you. Thank you very much. Now, indeed, the second member from the team from Dumbledore Law School, Miss Sofia Campolina. So, what did you think? Well, how was the preparation? How did you research on the topic?
I found the competition really exciting. I couldn't do it without my team and my coach, as they gave me a lot of instruction on what to do. I like very much the words of the student of Spiridon, if I pronounce it correctly, because a lot of this competition is about research and really spending time to find the correct arguments. And I'm really eager to participate a little bit more in the competition. Thank you.
Thank you very much. And now, Miss Samborska, on the side of Tilburg University. Could you maybe tell us how you found the topic? How did you prepare for it?
Can you hear me?
Yes.
Well, I definitely would reiterate what my colleague said, and also our opponent from Brazil. I think for me it was a very interesting and fun experience. It also allowed me to reach a bit outside the curriculum that I'm currently studying. So I think that was an interesting opportunity. And I also look forward to the next rounds, and thank you.
Thank you very much. So now I give the floor to the coach and after to one of the three judges. So Professor Lorena Bastianetto, can you hear us maybe?
Hello, Professor Hanj. I'd like to thank you, both delegations. It was a very fruitful debate, as we always have here in the Hague Debate Tournament. And it's a pleasure to be here and to see again the delegation from Tilburg University and to have you here with us in Brazil. Hope to receive you here in Brazil and other opportunities as well if you are interested in studying in Latin America. So feel welcome to come and also to interact with us more. Thank you very much.
Thank you very much, Professor Bastianetto. Now I give the floor to one of the three judges for the first impression. Of course, he will give his full impression in the form in a few days. So, but already maybe some elements he can share with us, Professor Schweitz.
Excellent pronunciation. Yes, Schweitz. First of all, I'm not sure what I'm supposed to reveal, or whether I should comment individual performances or to give you just some general remarks?
General remarks on two teams, for example, yes.
It's your first impression.
First of all, I very much I like the topic very much, and I do appreciate the research you have done. However, I would appreciate being both teams, especially the Brazilian, being a little bit more reactive, because the questions are designed to spark debate, not just to keep one line of argumentation and believing in the strength of your argumentation. Of course, whenever your arguments are strong, it's good, but it's helpful, especially in law debate, to undermine the argumentation of the opposing party. So this is just the general remark and recommendation I would give to you for the rest of the competition. But I have to say that you have done very, very good job, and I especially like your the style you the way of your presentations, and it was very professional and calm and very persuasive speeches I've heard. Thank you very much.
Thank you. Thank you very much. So before closing, I will have just one question for both teams, because it's a tradition, and it's the last match of the day as well. For the team in Tilburg University, have you been in Brazil or in South America already?
I haven't been yet, but I would really love to go, and thank you for this very kind invitation from the other team. It's really kind, and I hope that I get the chance to indeed come to South America and Brazil, because yeah, it would be a fantastic experience, I'm sure.
Thank you. And Mr. Contos?
Same here. I couldn't have said it better myself. I have not had the opportunity to come to any country in the Americas so far, but I'm definitely interested in maybe even seeing our opponents saying hi.
Yes.
Because you guys look really cool.
Great. So first contact, so to follow. On the side of the team from Brazil, have you been in Europe? Have you been in the Netherlands, maybe?
Well, I might say I have been not. It is my dream to get a chance to visit Europe, including Netherlands. So, till now, it is just a dream, but we may be even contact in the Netherlands if this competition succeeds well. And I'm very eager for the opportunity. Thank you.
Thank you. And on the side of your colleague as well? I didn't hear. I think you said yes, right? Yes. I'm not sure, but well, in any case, no, we can't hear you actually at this moment. But no, I don't think so. So let's of course make sure that you keep contact between the two teams, of course, to invite each other, and then we will of course follow for the next match. Next match will come next week. Next week you will meet actually the two teams, so the University of Manitoba and the University of wait a second, yes, of the West Indies. So that will be the next match. So many thanks again for joining for this match. Many thanks as well, Professor Schweitz. And next time you will receive your, actually this week you receive the topic for the next match. So many thanks again, and see you soon in Brazil.
Thank you very much.
And as well in
Dortmund,
in Tilburg.
Yes?
Thank you.
Wait a second, just for me.
Yes?
Do you have a question? Thank you very much.
Yes. So the students, you can leave the room, and of course we'll answer the question from Mr. Schweitz.